Okay, I think we're online. So a warm welcome from Berlin to all of you. Welcome to lawyers across the globe and around the clock for the rule of law. This is an unprecedented rule of law 24 hours webathon. My name is Annette Mutscher-Siebert, and as a board member of the German Bar Association, DAV, I have the honor and pleasure to be the moderator of this panel, which will discuss access to justice for refugees during COVID-19, past, present, and future. We're one of 12 different panels being offered for 24 continuous hours by bar associations around the globe to celebrate, address challenges, and defend the rule of law, all on this YouTube channel. The rule of law is not merely the stock and trade of lawyers, it's our core value. It's guaranteeing human rights and creating economic opportunity and development. And we lawyers are often the first line of defense. So the universal commitment of the world's lawyers to the rule of law inspired us and many other law societies to join forces and launch this first of its kind webathon. We're very proud to be a part of it. Let's get right into it. Dear guests, dear colleagues, dear panelists and speakers. First of all, I would like to thank the UIA, the AIJA, and the ABA for organizing this fantastic webathon, which focuses on the topic of human rights and the rule of law, and for inviting us, the German Bar Association, to organize this 2-hour panel. In the next 2 hours, we will have the opportunity to take a closer look at the threatening human rights situation at Europe's borders and at the effects of the current COVID-19 pandemic. How has COVID-19 affected access to justice for refugees? What is the current situation regarding access to justice on the European borders after more than 1 year of the COVID pandemic? What will be the effects of the pandemic with regard to migration movements towards Europe, and what effect will this have on access to justice for refugees? What is the state of play on the political stage? These are some of the questions that we will address in this panel. I'm looking forward to the assessment of the outstanding speakers we've lined up for you, and to discuss this important topic with them and with all of you. As you probably know, you have the possibility to ask questions over YouTube, and these will reach us over the chat. So we'll try to deal with as many of those in the next 2 hours as possible. Let me start with a short introduction. The ongoing pandemic has pushed the problematic refugee situation at European borders into the background of public attention. Still, the horrendous conditions persist in European refugee camps, and more people are in urgent need of humanitarian assistance and legal aid than ever before. The pandemic has hit all of us, but certainly the hardest, those most vulnerable parts of our society, which include the men, women, and children in the refugee camps. Access to humanitarian assistance and legal aid remains vital, but is endangered or at least rendered much more difficult in times of contact and movement restrictions. The report published by the European Union Agency of Fundamental Rights on the 25th of February this year clearly shows how much the COVID-19 pandemic has further deteriorated conditions. On Lesbos, in the Mavrovouni camp in Greece, asylum seekers continue to live in catastrophic conditions and are exposed to all kinds of weather in tents without heaters. In December, for example, the camps were flooded after heavy rains. These are problems that have existed not only on Lesbos for years and were already omnipresent in the prior camp, Moria. Nothing has changed for the better regarding the unacceptable conditions, despite numerous appeals from NGOs. And the pandemic is further aggravating the situation. Yet the pandemic is also having an impact on the overall migration flows to Europe. In response to the COVID-19 pandemic, The EU member states adopted a council recommendation on a coordinated approach to the restriction of free movement of non-EU citizens willing to travel to the EU. Not only, but also because of that measure, about 13% fewer people crossed the EU's external borders in 2020, the lowest number since 2013. Alarmingly, however, the number of people who died or disappeared on the dangerous migration route across the Mediterranean to Europe increased sharply between October and December 2020. Moreover, numerous credible allegations of pushbacks of migrants have been reported to have occurred with the involvement and knowledge of Frontex. As a result, asylum applications also declined during the pandemic. The reduced mobility of people in many parts of the world led to a decrease in asylum applications throughout the European Union by about 30% in 2020 in comparison to 2019. Unfortunately, we have to note that these declines in numbers are obviously not due to an improved human rights situation worldwide. On the contrary, it must be clearly emphasized that the numbers are declining even though the situation in most countries is worsening due to the pandemic. So this begs the question how migration flows will develop through the next month when Europe will most likely recover from the pandemic. I look forward to hearing more about this aspect of the topic during the presentations of Dr. Petya Androva and Dr. Maria Papaioannou from the European Asylum Support Office later on. But it is not only the sheer numbers of people arriving or rather not arriving in Europe that are relevant. Legal aid organizations expressed equally strong concerns about increasing difficulties in providing legal aid on the ground due to the pandemic. There are particular problems with the asylum hearings on Lesbos, which now have to be, at least to a large extent, be conducted remotely. Concerns here include specifically very short notice of the hearings, technical problems during the hearings, facilities not guaranteeing confidentiality of discussions, and the lack of access to hearing transcripts for applicants without lawyers. As a member of the Supervisory Board of European Lawyers in Lesbos, I'm following this closely, and I'm very happy that Phil Worthington, as managing director of the organization, will give us a more detailed insight into the work on the ground today. These conditions are diametrically opposed to the fundamental principles and values on which this European Union was built. The DAV and European Lawyers Associations emphasize time and time again that access to justice for everyone is an essential pillar of the rule of law. Without a fair process and trial, there is no justice. The litmus test for this must always be the situation for the weakest and most defenseless members of society. It is not enough that the rule of law is generally respected if refugees cannot rely on the same standards. Access to justice must generally be guaranteed by the state. Under the rule of law, the state has to guarantee conditions that allow asylum seekers to receive competent advice and assistance. If the state cannot guarantee this in exceptional situations, but only then civil society must step in. This was the situation when the former DAV CEO, Kurt Brugman, volunteered on Lesbos in 2016. At the time, there were many volunteers on the ground from different sectors, doctors, cooks, engineers, but overall, there were barely any lawyers for the thousands of refugees and migrants. At that point, together with the CCBE, the DAV initiated the European Lawyers in Lesbos, also in close cooperation with other European bar associations. And since 2020, also the French CNB is a shareholder of ILIL. Since its inception, the team of full-time and volunteer lawyers, in total more than 250 lawyers from 18 European countries so far, has provided free legal advice to over 11,000 migrants. This is how we take a stand for the values to which we are all committed in our legal profession. At the same time, the cooperation between lawyers from different European countries underlines that this common European challenge can only be met together. Despite the many difficulties over the past year, the COVID pandemic, the major fire in the Moria camp, attacks on NGO workers, the crisis on the Greek-Turkish border, the illegal team not only managed to keep the work going, moreover, the project was even extended to the Greek island of Samos and to Athens. I do not want to go into further detail on this, as Phil can tell us all about these developments firsthand. Yet one thing is certain: securing independent legal advice as part of humanitarian first aid remains a constant challenge. The high influx of migrants and refugees to Europe within the past few years naturally also posed challenges for the legal systems themselves. In particular, the administrative courts as the competent courts to review decisions of the respective national asylum agencies. They were suddenly confronted with an avalanche of new cases. I therefore very much look forward to hearing more about the judicial view on this topic by Boštjan Zalar. One must clearly acknowledge that the mandate of organizations like ELIL was never meant to be for eternity, but for those critical times in which state authorities were not able to fulfill their mandate under national, European, and international law. It is now the responsibility of the EU institutions and national governments to make the legislative changes that are required to make the Dublin system work again. Despite all differences of opinion also among EU member states and with human rights associations, I think it is fair to say that everyone agrees that the current system is not working anymore. The European Commission reacted and presented a set of proposals to amend the common European asylum system in September 2020. This initiative to reform the Dublin system after years of stagnation and deadlock, in particular in the Council, must be welcomed. Nevertheless, any reform of the current legal framework must ensure the protection of all fundamental rights for those concerned, and especially the vulnerable and weak. The DAV has already commented on parts of the reform proposals, and without wanting to go into too much detail, we're not convinced that the proposal does secure these required guarantees of effective legal protection and remedies yet. The crucial question is, will it be possible to find consensus among states and with the EU Parliament on this package of proposals? During the German presidency of the Council, some progress was made, but there is no agreement yet. I'm very curious to hear Ulrich Weinbrenner's assessment of the German presidency and the likelihood of an agreement within the next few weeks or month. This leads me to a key concern of the DAV's human rights work. Not only, but in particular, our engagement on Lesbos has shown us how important it is to ensure individual legal advice in humanitarian crises. For example, the residents of refugee camps find themselves in Kafkaesque scenarios, having to wait for months or even years for a decision in the asylum procedures without even understanding the process. Or, quite the opposite, new arrivals now often have only 2 days to prepare for the all-important interview in the new fast-track procedures. They find themselves caught entirely unprepared in a procedure that is so important for them and their future lives. Such hardly comprehensible circumstances pose an additional immense psychological burden. Legal advice offers support at different levels in these situations, which both the national authorities and the individuals concerned benefit from. That is true not only in European refugee camps, but in any kind of crisis. After natural disasters, like for example, the tsunami of 2004 or the earthquake at Christchurch, the people affected have often lost their entire lives as they knew them in one instant. Their house, their property, possibly relatives and friends. Here as well, qualified legal advice provided by lawyers and often organized through the local bar associations was one of the essential support services that were required on the ground in order to be able to offer people a perspective. This is why we believe it is so important that granting legal advice gets recognized as a general emergency humanitarian aid measure. Now, after that short introduction, I'm very curious to hear the insights of our speakers on this complex topic and to discuss with them and with all of you afterwards. Allow me therefore to introduce the outstanding experts of this roundtable. First of all, there's Phil Worthington. He's a British lawyer and the managing director of European Lawyers in Lesbos, and will provide us with a first-hand view on the current situation on the ground in Greece. Phil, can you raise your hand so we know which one you are? Perfect. Then the European Asylum Support Office is being represented by not one, but two panelists. Dr. Petya Androva, who is a senior analyst, and Dr. Maria Papaioannou, who is an information and analysis officer. They will offer insights into migration, data patterns and trends in the COVID-19 context, and developments in policy and practice. Can you also quickly raise your hands? Perfect. Then we have Ulrich Weinbrenner, who heads the Department for Migration, Refugees and Return Policy in the German Federal Ministry of the Interior, Building and Community in Berlin. He will speak about the developments on the political stage with regard to the reform proposal presented by the European Commission. This is Ulrich. And last but not least, we will hear Judge Boštjan Zalar. He's a senior High Court judge at the Administrative Court of the Republic of Slovenia, an ad hoc judge of the European Court of Human Rights, and the chairperson of the European chapter of the International Association of Migration and Refugee Judges. He also works as a trainer for judges and lawyers in the field of human rights. He will present us the view from the bench and from his experiences in training missions. Dear guests, I'm very pleased that so many of you have accepted our invitation, and I wish all of us an inspiring and fruitful discussion. Thank you very much. Handing over to Phil, the floor is yours.
Thank you very much, and good morning, everybody. I have a PowerPoint presentation, so I'll just try to share it. Hopefully this will work. So I hope you can see my screen now. As Dr. Mutscher-Siebert mentioned, my name is Phil Worthington. I'm the Managing Director of European Lawyers in Lesvos. She's already mentioned some of the key points, so I'll just very briefly introduce our work and then talk in a bit more detail about the situation and particularly the effects and implications of the COVID-19 pandemic. So as has already been mentioned, our organization was established in 2016 by the CCB and the DAV, the German Bar Association, and we're now also supported by the French Bar Association. Now, our work was inspired by belief in the fundamental importance of upholding the rule of law, defending human rights, and ensuring meaningful access to legal assistance. And I think the word meaningful there is very important. Because having legal assistance, which actually people can't really access, doesn't fulfill that criteria. We therefore believe that every asylum seeker should be able to receive free, high-quality legal assistance from an independent lawyer who specialized in asylum law before their asylum interview. And the way that we do what we can to try and address this in Greece is through a team, a kind of a hybrid team of full-time Greek asylum lawyers and volunteer European lawyers. And together those two elements work together to provide free independent legal assistance to asylum seekers on Lesvos, Samos, and now in Athens too. What our work focuses on is probably 75% of what we do is on asylum interview preparation. So that's preparing people for their asylum interview. Then the remaining 25% is family reunification under the Dublin regulation and assistance to unaccompanied children, which is both usually age assessment work and family reunification work. And as Dr. Mutscher-Siebert has mentioned, since we began, we've welcomed over 250 lawyers from over 18 European countries and have assisted almost 12,000 people. Looking now at the situation on Lesvos and Samos in particular. So as Dr. Mutscher-Siebert already mentioned, the kind of the refugee situation has diminished, I think, a little bit in the eyes of the media and the public, but nevertheless, the situation remains very serious on the islands, and there's still around 7,500 asylum seekers on Lesvos and almost 3,000 on Samos. And over 60% of the people in the camps and on the islands are women and children, and the majority from Afghanistan, Syria, and the Democratic Republic of Congo. So the situation remains very serious, yet there is no legal aid provided by the Greek state at the first instance stage. So there is legal aid at the appeal stage, but at first instance, so when people first arrive and when they go through their asylum interview, there is no legal aid provided. So that means that without organizations like European Lawyers in Lesvos and other NGOs on the islands, of which it should be said there are very few, people don't have access to speak to a lawyer or to get legal assistance before their interview. And people's interview, asylum interview, is of absolute fundamental importance. It's the only opportunity that people get to articulate their case in front of somebody in the process, because the appeal stage is all done on the papers. So the single asylum interview that people get is their only chance to set out their case. And obviously that determines the outcome of their application. And so it is crucial importance and something that we believe that's absolutely vital for people to be able to understand the process, understand the criteria, understand the steps, understand how their case will be assessed and the kind of questions that they'll be asked, in order to actually be able to articulate their case in a way that reflects their need for protection. As has already been mentioned, there's been reduced arrivals on both islands, yet still significant numbers remain. Since the beginning of 2020, we've seen increasingly restrictive asylum law in Greece and associated policies. And of course, with the COVID-19 pandemic, there's been significant outbreaks on both islands. Lesvos, for example, was a red zone in Greece for many months. There have been nationwide lockdowns, 2 nationwide lockdowns in Greece, one from November to earlier this month. And as well, there's the fire, as has been mentioned, on Lesvos, which destroyed the old Moria camp and resulted in originally around 13,000 people being transferred to a new temporary camp. Since then, there have been transfers from Lesvos to the mainland, yet still thousands of people remain in this temporary camp on the island. Of course, the COVID-19 pandemic has had a serious impact and continues to have a serious impact. Initially, from March 2020 onwards, there has been increasing restrictions that have been imposed on the camps themselves, and that relates both to people being able to access the camps. So NGOs and organizations like ours have restrictions on accessing the camp, and similarly there are restrictions on people leaving the camp. So this has varied at different times across the year, but basically people can only leave the camp at certain times and need an appointment to come and see a lawyer or to come and see a doctor. So obviously that adds additional restrictions. There has been an attempt to address this, to mitigate this, by launching a new online platform, and this was to balance out the restricted access to the asylum offices in a physical sense, because of course, for many months in the last year, the asylum offices themselves have been closed or have only been open in certain circumstances or for certain cases, certain appointments. So a new online platform has been launched, which is particularly in effect on the mainland. And I suppose this is one of the many examples we've all seen over the last year of technology kind of running to catch up with the situation, because whilst an initiative like this is a good one in theory, in practice it's been presenting some very significant challenges. So, for example, on the mainland, to schedule an asylum interview, people have to go onto this online platform and schedule it in that way. Obviously, for people who are maybe in a transitory situation, in a camp situation, that can be difficult. Indeed, it's actually even quite difficult for a lawyer to go on, a lawyer representing an individual to go on and book an appointment. So whilst it's a good idea, there are still challenges in terms of implementation. As Dr. Mutscher-Siebert mentioned, there are two major concerns, I think two major impacts of COVID-19, which may not necessarily be, well, I think that one was caused by COVID-19, the other is almost running a little bit in parallel. The thing that maybe is running in parallel is the extremely quick interview process. And I say that's running a little bit in parallel because actually that was foreseen in the new asylum law that was brought in at the beginning of 2020, so pre-corona, and is also something that is very much envisaged in the new proposed asylum pact, which is this idea of having very, very quick, fast-track interview process. And of course, corona has also affected this. And the reality is at the moment that it's absolutely normal for people to get their interview date with only 1 or 2 days notice. So it's totally normal for somebody to be told today that their interview will take place at 7 a.m. tomorrow morning. We've even had cases both on Lesvos and on Samos of people being given only 30 minutes notice. So they've gone to the asylum office and been told, actually, your interview will take place in 30 minutes. Now, of course, these are the exception, but it is absolutely the norm that people only get 1 or 2 days notice. And I think it speaks for itself how difficult that then is to provide legal assistance to people in such a situation. It's almost impossible if somebody comes to us on a Wednesday afternoon and says, my interview's tomorrow morning, for us to give full, proper interview preparation. We normally try and do two-hour sessions as a minimum. So obviously that would be impossible in such a situation. The other element, which is definitely related to COVID-19, is that now interviews are being conducted remotely. Almost all interviews have a remote element, and this was piloted on the islands and is now being also rolled out on the mainland too. Now, of course, this is a situation which is understandable given the current situation, but has had numerous serious rule of law issues. We've had many instances of people having difficulties with the connection, so the internet connection cutting in and out when people are in the middle of their interview. Now, if you can imagine that both the caseworker, the interviewer, and the interpreter are often remote, all it takes is one of those connections to break temporarily, and it completely compromises the quality of the interview and actually what's being said and communicated. The other issue is that of confidentiality, particularly in Lesvos, in the premises in Lesvos, there was a catch-22 situation because in order to try and comply with COVID-19 protocols, it was necessary to not have people in an enclosed space, but of course, opening windows and opening doors then compromised confidentiality. And we had numerous issues of people complaining that they could hear what's going on in other interviews in adjoining rooms. Now, bearing in mind that around 70% of the population on Lesvos are from Afghanistan, then of course, statistically, the chances were that people could also understand what was going on and what was being said in the adjoining rooms. And even that idea that somebody could hear would then compromise the interview process because people will be inherently more reticent to articulate things, never mind the serious protection risks that could be associated with it. That situation continues, and the interview process continues to go very quickly. And so in response, we as an organization have sought to try and address this and be able to continue working during the pandemic. So initially, in the first few months, we were working purely remotely. And now we kind of have a hybrid remote and in-person model. So we have our full-time team on the ground, and we have our full-time Greek lawyers on the ground in the 3 locations, plus support staff. And then we have a team of about 15 volunteer asylum lawyers, who all of whom have volunteered with us previously, who are providing assistance remotely. Now, of course, one of the considerations in all of this is how to do this in a suitable way that actually safeguards confidentiality and privacy. Just in the final slide, I'll touch on a couple of things that we've done in that regard. But of course, these were new issues that we hadn't confronted before. So we restructured our team and how we work in order to be able to continue providing assistance during this time period, particularly as actually the number of interviews significantly increased during the period, and the notice in which people were getting their interview dates significantly decreased. So actually the whole process was going much, much quicker, and is going much, much quicker at a time when providing legal assistance is more challenging. And I think that has clear implications for the rule of law, and also maybe clear implications for the situation when we look forward for the new Asylum Pact, because what we have found is that actually it feels like there is a risk that the interview process, the rule of law, the integrity and the quality of the process is being compromised by a focus on speed. And whilst we absolutely think that having a quick interview process is important, this previous situation that we had on the islands, whereby people would wait on average 2 years between arrival and decision, of course, was too long. Yet I think there is a risk that we're now currently in the other extreme. Having only 1 or 2 days notice of interview is of course, I think, too short to be able to be fully prepared for such an important process. Finally, in terms of our structure, since 2019, we've been in collaboration with 6 major international law firms who provide additional assistance to increase our capacity as well. This was affected by COVID-19 because previously these volunteer lawyers would come in person, and now we've transitioned that to a remote secondment model. So they're still assisting, but from distance through remote assistance. And then just finally, in terms of the some of the challenges and the lessons learned, and I suppose I should say that, of course, we're still learning. We're still in the process and still going through and developing responses to this. I think it's fair to say that our team, myself included, were initially pretty skeptical about providing remote assistance and continuing working, how we would continue working in the COVID-19 pandemic. Of course, for lawyers, we're all very used to doing things face-to-face and in person. And for asylum cases, it's maybe even more important because that critical rapport, that critical relationship between the lawyer and the asylum seeker is of paramount importance, because it's through that you establish trust with your client, and provide a safe space for them to explain and recount what often extremely traumatic events, and in many cases it may be the first time that they've ever actually articulated it to somebody. So to do that in person, to develop that in person, is already difficult. To do it when the lawyer is on a screen is, of course, much more even more challenging. When you couple that in with the technical and the practical issues, of course, as with everybody, we've also had issues of connectivity and problems with people dropping out and not being able to have a stable internet connection, plus practical issues in terms of how to set up the room, trying to enforce social distancing when providing assistance, people providing consultations, interpreters working whilst wearing masks. All of this, of course, adds to the challenge. But nevertheless, looking back a year now, I think that the remote work, the remote assistance has been absolutely critical in ensuring that we can continue to provide legal assistance during this challenging time, and that, looking forward with the ongoing travel restrictions and the uncertainty about what may happen in the future, I think that we will always have now a hybrid model, some element of remote assistance. And I think that this just further illustrates that the incredible value of that lawyers can provide remotely, that bar association members the assistance they can provide, even in the situation where we may initially think, actually, this isn't possible, or it wouldn't be of a suitable standard. We won't be able to provide the right quality of advice in the right confidential circumstances. I think our situation whereby we've enabled a structure whereby people can still come to our office, they sit in one of the private consultation rooms with an interpreter, usually in person, and a lawyer dialing in exactly the same situation, trying to make it as similar as possible to what they would have in person, illustrates that it is possible to provide remote assistance, and that particularly at this moment, that's of ever greater importance given the situation, both with the pandemic and more generally with the rule of law on the Greek islands. So I'm very happy to take any questions about any of those things, and thank you very much for your time.
Thank you so much, Phil. That was really inspiring to hear how flexibility really made it possible to continue advising in this time of need, because the interviews continued, so the need for consultancy remained, and remote consulting has become a part of daily life. I had one question in particular to open this to the panel. So you mentioned the preparation times, and I know that this whole topic of shortening the process is one that also is a very relevant one in the European package. So Ulrich, I would like to hear your opinion about what exactly would be an appropriate time frame, because it's more about the challenging deadlines that the package talks about. But then again, we all know it has to be shortened. It has to be much shorter than the prior 2 years, but we will need preparation times for interviews and preparation times for handing in challenges. So can you elaborate a bit on that, perhaps?
Yes, thank you very much. I would very much like to do so. So that is a question which we all also have in Germany, and which all national asylum systems have, and where is no proposal by the Commission in the CAS package we received on the 23rd of September last year, because that's very much up to the member states. But certainly there is a time window, if you like, which on the one hand takes into consideration the special situation, counseling, but as well a post-traumatic situation in which refugees might find themselves. And on the other hand, there is in the refugees' interest, but as well on the countries who have to deal with the individual cases, the interest that a fast procedure is carried out relatively fast. So what we in Germany think that about 2 to 3 months after the arrival, where you really have enough time to settle down, find yourself, and so on, to adapt yourself to the new situation, might be appropriate. But on the other hand, if you live in a tent on an island in a delicate situation, that might be too long. But Phil is absolutely right. It is not appropriate just to have a very short notice of a few days before before the important interview is scheduled. So that has to be sorted out in practice. But I would say about a handful of weeks, a month would be a good time to a good compromise between the two different aspects I was trying to depict. But nevertheless, that's always very difficult in practice to carry that out, taking the interpretation challenge and all the other challenges, organizing the different interviews and so on. But that is really a challenge for everyone.
Thank you very much. If any of the panelists have any questions of their own, feel free to ask Phil about them now.
Maybe I would just respond to that last point a little bit, because I think it's a very important point in terms of the situation, the context in which people are in. I think that it's kind of difficult to explain the exact process that people go through on arrival, particularly with COVID and quarantine and things like that. But I think that it goes without saying that when people arrive into the new camp on Lesvos or onto Samos, their first thought is not, where can I find a lawyer? It's, where do I get food? Where do I go to the toilet? Where am I sleeping? What's the situation around me in terms of security? What's going on here effectively? And I think that one thing that is of absolutely fundamental importance in any future situation, in any future camp on Lesvos or any other places, and under the pact generally, is the critical importance of legal information as well, right from day one, that people receive as soon as they arrive. Information in a language that they can understand, that explains that they are going through a legal process and these are the steps, and provides information about lawyers who can assist them. And that immediate information gap is addressed to the extent that it can be, and then provides the opportunity for people to then go and get concentrated, detailed legal advice. And they know how to get that, and they know as well why it's important, because I think it's maybe difficult for us to understand that a little bit, but it is absolutely the case that many people, when they arrive onto the Greek islands, through absolutely no fault of their own, they don't know the process they're going through. In many cases, they don't even know it is a legal process. I think it's simply an administrative process. Don't know that there are criteria that need to be met. So that critical initial information is of paramount importance.
Absolutely. Thank you very much to both of you, Ulrich and Phil. If there's one further question I think we can perhaps quickly bring in from the participants about how remote assistance works in practice. Do you provide the technical means? Do you have a room where the migrants can sit and have that confidentiality? Do the lawyers and the translators sit in the other room? You already described a little bit how it works, but perhaps you could just add 2 or 3 sentences on that.
Yeah, sure. So the way that we do it is that we have our offices on the 2 islands and also in Athens, and we have in each office 4 or 5 confidential interview spaces, which we had before the pandemic and were where we did the interview preparation and consultations. Previously. We've now adapted those for the situation, and the way it works in practice is that the asylum seeker will come to the office. The interpreter, 9 times out of 10, will also be there in person, and we have the project management staff who then assist to actually, in a practical sense, organize it. So the asylum seeker and the interpreter will be there in person in one of these consultation rooms, and then the lawyer will dial in through Skype or WebEx or Zoom directly. One thing that has been kind of mentioned or suggested at some point was, providing directly links to people for them to be able to access it on their phone from wherever they are. But of course, there are huge confidentiality concerns then, because, in a camp situation, of course, people can overhear so easily, and never mind the technical challenges. So we also we always insist that people come to the office where we can close the door, have it in a soundproof room, and people can have a consultation that is as similar to one that they would have in person as is possible.
Thank you very much for clarifying that. So let's move on to our next topic then. And I would ask Petya and Maria to enlighten us about the statistics of how migration flows have developed and what they see in the future.
Thank you very much, Annette. I'll take the floor. My name is Petya Alexandrova, and together with Maria Papaioannou, we will present to you some insights on asylum trends and some of the policy and practical changes that EU plus countries implemented during the pandemic. I will start sharing my slides, and before starting with the presentation itself, I need to explain what EU plus means, because from the perspective of the European Asylum Support Office, we look at EU member states plus a few associated countries, namely Iceland, Liechtenstein, Norway, and Switzerland. So whenever I talk about the EU plus, this is the group of countries that I mean. Okay, let me start with some numbers and some trends over 2020. One of the main developments was that there was an overall decrease in asylum applications by about a third compared to 2019. Overall, 484,700 applications were lodged in the EU plus countries. As you can see in this figure, there was clearly a trend in terms of how this decrease happened. In fact, in the first 2 months of the year, numbers were going up. But then in March, there was a gradual decrease, which actually occurred in the second half of March. And then in April and May, numbers were low, were really extremely low compared to earlier periods. And in June, they gradually started catching up. And in the second half of the year, the number remained more or less stable at the EU plus level, but it was way below the number we had before, more or less 2/3 of the level prior to the pandemic. This effect was clearly related to COVID-19 and more particularly to the emergency measures that were implemented in EU plus countries. And although these measures differed a lot, and we'll hear more about this from Maria in some respects, generally they were implemented almost everywhere. With slightly more stringent measures in some countries than others. We did an analysis at EASO trying to compare overall stringency of movement restrictions using available data from the Oxford tracker, and then the number of applications that were lodged. And we clearly saw a very strong inverse correlation there, meaning that when measures were most stringent, then also applications were going down or were the lowest. And this relationship was slightly less strong in the second half of the year. And this is probably related to the fact that EU plus countries already had some experience dealing with this pandemic. So they managed to implement different practices that made it easier. Generally, this comparison that I'm talking about was with movement restrictions only. But of course, there were different measures undertaken by national asylum offices. Some were even closed partially or had to reduce services. So this certainly had a very huge impact. You see also in this figure, which were the main receiving countries last year. Germany, France, and Spain were the top 3, and they accounted for about 1/3 of all applications that were lodged in the EU plus overall. And generally, there were decreasing trends in most countries, with some exceptions, most notably countries located around the Balkan routes, such as Austria, Bulgaria, and Romania, where applications actually increased, in the case of Romania, to unprecedented levels. In terms of receiving countries, the main countries of origin, the main countries of origin were Syria, Afghanistan, Venezuela, Colombia, and Iraq. And these were the same countries as in 2019. However, for all of them, numbers went down. Important to note is that Venezuelans and Colombians, for example, in this group, have visa-free access to Europe because they can enter the Schengen zone without the requirement to hold a visa. Let me move to another side of the story, which is the output side of asylum procedures. Here we look at first instance and second and higher instance, which might be actually more relevant in the context of this meeting today. One of the most important trends last year was that there were more cases closed than applications lodged overall in 2020, and this happened for the first time since 2017. What does this mean? Of course, we've been talking already today about the different time period that it might take between the lodging of an application and a decision, and generally this is not immediate, and there might be different times. So when we talk about decisions being issued, there is certainly a time gap, so there is catching up of applications that have been lodged potentially even in previous years or earlier this year. The case closures also comprise not just decisions at first instance, but also closures in relation to, for example, Dublin procedures or discontinuations of cases where there has been a withdrawal of application. The overall number of decisions was 534,500, excuse me, and this was more or less similar to 2019. So basically, while decisions remained stable, applications decreased, therefore we had more decisions at first instance. The recognition rate was 42%, which was similar to the previous year. This recognition rate is sort of inclusive, so it does not only consider refugee status and subsidiary protection, but also humanitarian status granted under national protection schemes. About half of the positive decisions actually granted refugee status. If we move to second and higher instances, here we're talking about appeal and review, and it's important to know that there are different procedures about these stages in the EU+ countries, which means that in some cases, an application might have to be reviewed by the same asylum authority, whereas in other cases, it might go to a judicial authority, and there might be different stages in this procedure. But in total, there were 236,500 decisions issued in the EU+ countries at second and higher instance, and this was a lower number compared to 2019, lower by about a fifth. At the same time, the recognition rate remained rather stable at 29%. Here, again, important to know, don't compare directly the two recognition rates of the two different levels, and don't try to add them together, because it is not necessarily the case that only negative decisions are appealed. For example, decisions granting subsidiary protection or humanitarian status might also be appealed if this protection seems to not fit the needs of the applicant. I want to conclude my part by pointing at cases which still remained open at the end of 2020. There were 773,600 cases pending at all instances. This was a lower number compared to the end of 2019, so to a year earlier. And this decrease was largely related to the decrease in applications, to a lesser extent, of course, possibly also to somewhat fewer decisions issued at higher instances. Internal EASO analysis, which compares these Eurostat data to EASO early warning and preparedness system data, shows that most of the decisions, well, just over half of the decisions still pending at the end of 2020 were actually at first instance. So it's important to know that this backlog is relevant both for asylum authorities, but also for judicial authorities. And I will stop my intervention here and hand over to Maria, who will continue with digitalization.
Thank you. So now I will take you a little bit to the other aspect of COVID and the impact on asylum procedure. One of the key developments we encountered in 2020, and it still affects the procedures, is the digitalization of the asylum process in the COVID area. In an effort to uphold the confinement measures and abide by the social distancing imperatives, many national authorities resorted to electronic tools and/or portals or digital services. In this context, in administration, including the automatization of processes, enable authorities to reduce daily office interactions by offering e-services, improve the efficiency of the national asylum systems, and allowed the timely processing of applications for international protection. More analytically, for the lodging and also the access to the authorities to to provide documents. We saw that access was allowed with prior notification by setting up an appointment via phone or e-services. In Sweden, in particular, applicants were requested to contact the Swedish Migration Agency primarily by email, telephone, or through e-services. And to address the increased needs, the agency added more resources to enhance the telephone and email services. Many national authorities resort to electronic tools and portals to allow the online lodging of the application when the registration has already taken place in order to submit mainly remotely additional documentation. It should be noted that efforts to regulate access to asylum via online appointment systems were ruled out by the courts as applicants couldn't request material support at the moment of submitting an online request for an appointment for registration. Moving on the provision of information, we saw that a lot of online materials like YouTube and video presentations on site, websites, social media, and apps were developed by the competent authorities in an effort to provide information not only on the asylum procedural steps, but also to inform the asylum seekers on the preventative measures and the restrictions in place in the countries. Regarding the processing and status of applications, we saw that since June 2020, applicants may check the status of their applications online in some additional countries, the ones that didn't have this possibility, like Czechia, France, and also Greece. Moving on, of course, we saw that remote personal interviews and video conference were also a new development in many EU+ countries in order to enable the continuation of the asylum procedure. In some member states, a mixed approach was opted, for instance, video conferencing and face-to-face presence under strict protocols, particularly when the asylum seeker and the case officer are both in the asylum authority building but in different rooms, or when the applicant can be interviewed at the accommodation center and the case officer is placed in the asylum authority. Of course, moving on to the next slide, new solutions come all with new challenges. We see that the resilience and preparedness of the asylum system is a key to adapt to the new conditions. That was also the case for the reception systems that we see as many emergency structures were set up in order to accommodate newly arrived people. The resumption of operations by judicial institutions has led to the review of emergency measures in asylum and reception procedures. In some cases, as mentioned before, the consequence was the immediate annulment of certain measures. The new tools and processes in the immediate response to the pandemic, we see that they don't longer represent just a short-term solution, but it's an emerging new normal. So in European societies and legal systems, it has long-lasting effect on the implementation of SEAS. For us, it is important that procedures and safeguards in asylum practices should be aligned with SEAS framework to avoid any arbitrary revision of rules and any practices that could infringe on the existing legal framework. In this regard, EASO actively supports the member states with capacity building, information exchange and sharing of best practices, as well as continuous training activities adjusted to the COVID requirements. In this context, we have published 2 sets of practical recommendations. They encompass a wide range of preconditions and arrangements whose availability and eventual setup are crucial to ensure the efficient and effective contact of these activities. The first one refers to the conducting of personal interviews remotely. The aim of this guidance is to provide practical recommendation on the organization of remote personal interviews and elaborates procedural safeguards and other aspects that should be taken under consideration by the national authorities, like to ensure the quality of the interview, like practical arrangements prior, during, and after the interview, technical arrangements to ensure security and confidentiality, legal considerations, interview techniques, quality-related considerations, etc. The second set refers to remote online registration, and it also touches upon different aspects of the procedures. I would also like to draw your attention on our reports that we have published. There are 3 EASO reports on the impact of COVID in asylum and reception systems in 2020. There was also a new report that came out last week in cooperation with CMN and OECD about the COVID impact in migration. And last but not least, I think that it would be also relevant for your work, the case law database of EASO, where we have collected a lot of cases, court cases from national and European institutions on the COVID restrictions and the COVID measures that might have particular interest for you as lawyers. As we saw case law regarding Dublin cases, first instance procedures, detentions, etc. So feel free to access directly our tools, and please let us know if there are any other questions from your side. Thank you.
Thank you so much to both of you. That's absolutely fascinating, the way you're providing the figures to what we all assume is happening, but you can show it in statistical terms. Opening up to the panelists again, my initial question was, so it kind of seems as if remote and digital advice is there to stay in the asylum process. So we'll have to deal with that in future. It might be a positive feature for information provision, as Phil said before. It might be a good way of reaching out. Do you have any figures or statistical information on how that works for asylum seekers? Is that something they're comfortable with, using these online tools?
So from our side, we are coordinated closely with the national authorities. That's why we had these practical recommendations issued in order to create some standards, let's say, on how the processes should be implemented in this different framework. So we are in cooperation with the authorities mainly in this regard. And we also have increased training support to the staff, staff of the national authorities, in order to get acquainted with the new standards when this is necessary.
Okay, thanks a lot. Phil, I think you had a question. Yes.
Sorry, yes, sorry. I'm not sure whether it's a question or a statement, but it is just to say that, you know, of course, having frameworks and having guidance and is crucial and very welcome. But I think the practical implementation of these things is extremely relevant and important, and we need to see the view from that perspective as well. I mean, I just think of a case that we had whereby, and of course, you know, we can't extrapolate out from single cases, but this was quite a powerful illustration, I think, because it was an individual, an unaccompanied minor who had been assessed as an adult he claimed to be a child. We were in the process of challenging that and getting the documentation, but because the interview process was happening so quickly, he was called to interview. He went to an interview without an age assessment. So he was in the interview, and that was his opportunity to then argue his case that actually he should be considered to be a child. But he was there in the room on his own, an interpreter dialing in by telephone, the caseworker also dialing in by telephone. Nobody could see him. There was no screen, there was no video. And in that situation, I think it's next to impossible to actually properly articulate such an important thing like the age of an individual that's been challenged in those circumstances. So I think that balance and that focus on the primacy of the rule of law and the primacy of the integrity of the process, and ensuring that that a fair and robust procedure is in place, not one that is necessarily the quickest, or not one that is necessarily the enables things to move in this situation. That we need to focus on the integrity of the process and avoid situations like that one.
Thank you very much, Phil. That was actually kind of the background of my question, to differentiate between information provision and the real consultancy and interview preparation. That might be different things, and remote and digital might be helpful for the one, not that helpful for the other once we're through that pandemic, but we'll see about that. There was another question about the backlog, and I would like to address that to Boštjan as well, because he's got firsthand insights into that as well. How have you experienced that during the last year? There have probably been fewer cases, fewer decisions as well. Can you tell us on what you've seen in the last year?
Thank you, Annette, for the question. But of course, I can only speak for my court in Slovenia. We have backlogs, but we have backlogs because there are not sufficient number of judges in the department which deal with the asylum disputes. And as regards the case of Slovenia, I would say that there was a decision of the President of the Supreme Court to lock down, also the courts, except for the urgent cases. And our department, the Administrative Court, decided that the asylum cases are urgent cases. So COVID-19 did not affect at all the case law management in my court because of the decisions of the judges that we have to deal with these cases. And we have facilities for teleconferences, but we had oral hearings at the court. We took all precautionary measures, but we had hearings in person as regards the control of detention, and also as regards the claims for international protection. Because, for example, when a person from Iran changes his religion, I hardly imagine that I can have a meaningful oral hearing with the applicant remotely online. So I fully agree what Phil Worthington has said, and I have nothing to add to his intervention concerning the use of digital tools.
Thank you very much. In light of the time, I would love to move on. We've got a couple of additional questions, and we'll definitely deal with those later on, but I would like to give the floor to Ulrich first to give us his view on the EU Pact, the German presidency, and what is to be expected in the future.
So many thanks, Annette. It's really a pleasure being a member of this panel and this DAV very interesting discussion. So I will try to be as short as possible. First of all, but an introductory remark. It was just said that nothing has changed to the better on the Greek islands. I would, from my Berlin perspective, nevertheless try to shed a light on the numbers we had. Phil said that there are still 10,500 approximately in Samos and Lesbos together, but we had 42,000 on the islands more than 1 year ago. So, and we had the discussion on the procedures and how fast, or maybe a little bit too fast, they're now carried out, and we had people waiting for 2 years for any decision on their fate. So there lots have to be done. Lots have to be done, no doubt about that, but nevertheless, a lot has already been achieved due to really a change of the Greek policy towards migration and the management of the migration on the island, and as well to a certain extent to solidarity measures from European countries like Germany. For example, we have since 18th of April last year taken over 2,700 people from the Greek island, vulnerables, unaccompanied minors, families, and so on, to have their cases checked in Germany for humanitarian grounds. So lots still has to be done, but nevertheless, that's something I want to hint at the beginning. So Germany had the presidency in the second half of last year, which was very much affected by the COVID situation. We hardly had any meetings in Brussels, which is a very important tool, not only to have a working group or ministerial meetings via video conference, because a real discussion is hardly able to be carried out in the group of 27. But nevertheless, we were able to come up on the 14th of December at the final Council of the Interior Ministers with the presidency conclusions, in which all member states showed their willingness to discuss the further development of the European migration and asylum system on the basis of the Commission's proposal, which we received on the 23rd of September. So after 3 months, that was the first political assessment, which was necessarily a quite vague and broad one. So the willingness to discuss on that basis, a broad consensus on the importance of the so-called external dimension. So in order to avoid irregular migration, in order to avoid any kind of people leaving their country without being forced to leave their country, we have to improve the cooperation with the countries of origin, with the countries of transit. There was a broad consensus on that. But nevertheless, on the key questions, the key terms which are on the table when it comes to any proposal, which are on the one hand solidarity and on the other hand responsibility, there was not really a compromise which could be found by December last year. So you are aware that the Commission came up with its proposal on the 23rd of September, which was a 400 pages package comprised of 6 legal acts and lots of communications on SAR cases and so on and so forth, a really comprehensive piece of proposals. That was based very much on the assessment by the Commission that the Dublin system is dysfunctional, that it has to be improved, that we have lots of irregular migration movements, and that we have from outside into the Union a lot of secondary irregular migration movements inside of the Union. That is in a nutshell the assessment that the Commission made. and which was the basis of this huge package of proposals they put on the table. When it comes to the actual state of play, now that's done on the working group level. We have the screening proposal for the screening regulation, where the first reading was finalized, and now it's up to the Portuguese presidency, which took over naturally after the 1st of January, and they decide together with within the council on the way to make things progress, and they decided to bring the screening regulation to the JAI councillors, so directly to the Brussels-based representatives of the or members of the permanent representatives of member states, and then to COREPER to have a partial agreement on the screening directive. That is, there are still lots of open questions, but that is as well the procedure you can imagine for all the other pieces of legislation: the Asylum and Migration Management Regulation, and the amendment of the Asylum Procedure Regulation, where we have considerable articles on appeals and the suspensive effect of appeals in Article 53 and 54. But these will be papers most likely where lots of different positions from member states will be reflected, but that does not yet, at least, bring Council closer to the solution of the basic questions which are underlying the overall discussion, and that is, what should be the role of the frontline member states, as they call themselves. They have created a group of interests which they call MED5, comprised of Spain, Italy, Malta, Greece, and Cyprus, very much focusing on their interests as member states of first entry, which is in a way understandable. And they are very much still opposing the Commission's proposal, which still retains the Dublin approach, so the responsibility of the first country of entry. And they say that is not the right way to find a solution. On the other hand, you have a number of member states, not only the Visegráds, a number of member states who don't want to be affected by migration at best at all. And they do not show any willingness to render a real solidarity to the member states of first entry. And these are, very, very broadly speaking, still the two groups of member states. But on the other hand, you have as well a group of member states who do not necessarily belong to these two, but whose policy and whose position is very much influenced by a certain migration fatigue, who are not yet willing to be part of a constructive group of member states to which Germany does belong now and will belong. I'm quite sure about that. But we need to break this backlog in which we are, a necessary large group of member states, not necessarily 27, but at least 12, 15, who are willing to make compromises, who are willing to take over responsibility in order to come up with a final proposal which will be acceptable by nearly all of the member states. So we are doing, next to what I just said on the technical level, simulations. What does the Commission's proposal mean with support from EASO? Very many thanks for that, in numbers for member states, because that's very important to have a better understanding. If you take an influx of a given year, maybe 2019, what would the Commission's proposal mean? What would be the numbers of people in the screening process, and so on and so forth? That's very important. But nevertheless, there still needs to be the necessary political impetus, and I think that to find a solution. And I think that has to come from the heads of government. that is, it's a subject which is politically so sensitive that I can hardly imagine that the ministers of the interior have the necessary saying to decide that by themselves, and the necessary large group of ministers interior and make the decisions by themselves. I think at a given moment that has to be decided by the heads of government, and not institutional thinking in one of the European Council meetings, but has to be prepared informally under a core group, if you like, and then things have to be moved in that direction. And that is my personal impression how the future could look like in order to come up with a proposal which seems to be acceptable for at least the necessary quantity of member states. But I'm a little bit skeptical. At least I'm sure we have not yet reached that political moment, this kairos, if you like. But I hope it will come at a later stage. Given the fact that the numbers are relatively low, the influx numbers we have due to the corona situation, and we have one necessary requirement is that the number of member states who think that they can live quite well with the actual legal basis, with the actual situation, that this is that we can convince other member states that there has been an improvement, that we could not retain the system as it is now and try to mingle through in a way. There has to be a new approach following the lines which I mentioned and the procedures which I mentioned. But I think that is not yet the case now. We have to finalize the readings technically of all the legal acts, and then it might be the right moment for such a an endeavor on the heads of government. Many thanks.
Thank you very much, Ulrich. I would very much like to see that. I'm just not sure when we will. Perhaps just one quick question from my side. Do you think the EU will use its tools to a greater extent in the future to convince member states to come to a consensus, or?
So, good question. So I think finally it is up to member states to decide. About 1 year ago or more, we had the idea that the financial framework for the next 7 years, which was under discussion under the German presidency as well, might be in a way connected to the CEAS, and that. So a connection between the financial questions, which are extremely important for member states looking for the next 10 years, 2 billion euros and so on, would be connected in a way. But that did not materialize, first of all, because we had the CEAS proposal too late on the table. That only was presented in September, and when the financial discussions were already at a very high and on a level more advanced. On the other hand, the financial discussion were already overloaded by human rights questions by certain member states and other aspects of extreme importance, that I fear there had been a certain reluctance to take migration as another really sensible political subject on board as well, and that would risk maybe overload the boat and would risk the compromise at all. So that is the only thing I can imagine where a certain pressure, if you like, by the European Union on member states could have been used, but that is now finalized until 2027. So whether then we will have a next chance in 25, 26 in preparation of that, I'm not sure about that. So it's up to member states. It's up to member states. It's up to the political discussion in member states to forge and to build the necessary internal willingness to participate in such a European solution.
Thank you very much. Yes, and up to bar associations, of course, as well, to give their views on how this proposal should look and what it has to safeguard to make sure that the rule of law is upheld and that access to justice is guaranteed. I don't know whether any of the other panelists has any questions on that. Otherwise, I would have one from a participant that is a bit in a different vein. It's about the impact of AI on asylum law and asylum procedures, because the EU Commission's legislative proposal on AI allows the use of artificial intelligence, also in the field of migration and asylum procedures, although it identifies it as high-risk AI systems. Can any of you, Phil or Ulrich or Boštjan or Petya Maria, comment on how you see this playing out?
Just maybe, I mean, in relation to that question, if it's AI in the sense of decision making, then I'm extremely skeptical. Of course, legal tech is very important and can be used in many different ways. We use legal tech to assist with our work, but AI in terms of decision making, I think would be extremely difficult, because as has already been mentioned, it's often so nuanced when you're assessing somebody, when you're talking to somebody. It's so difficult often to kind of get through the layers that may be there in terms of the trauma, in terms of maybe not 100% understanding the asylum process. That all of the different elements mean that it's very, very difficult to start with. Never mind then if there are then very, very sensitive issues. As I've mentioned, in many cases, when we talk to applicants, it may be the first time they've ever actually said out loud to anybody what happened to them. And that can take hours of consultation to even get to that stage. The idea that then AI could then somehow assess that in a decision-making situation is very, very difficult for me to comprehend. Maybe as well, it could just take this opportunity to just mention one thing in relation to Mr. Weinbrenner's presentation, which is just to emphasize from our perspective that this is, of course, a European issue and should have a European solution, and the solidarity and relocation mechanisms that have been mentioned are extremely positive in that regard. I would say, though, just to emphasize that it is quite difficult, maybe in my naive little viewpoint, to see that this is such a challenging issue when the numbers involved are so small. In the grand scheme of things, in the whole European Union, the numbers involved, 100,000, 150,000 people in Greece in total, is fractionally small. And I just remember something that really struck me, which was one of the a colleague of mine who was actually working for the camp authorities in Moria said that if at that point, and that was the time when Moria was at its absolute largest in terms of capacity, he said, if only Sweden were to take all of the people in Moria, then it would work out at 5 people per Swedish municipality. And that's just one country, and it'll be 5 people per municipality. The numbers involved are very, very small. And so it's then frustrating, I think, to see that these really great solidarity and relocation mechanisms often face resistance and delays in being implemented.
Ulrich, you wanted to respond directly, I think.
Yes, many thanks. Phil, you're totally right. The numbers are small, but that has to be seen against the broader political picture, as you're totally aware. So I mentioned that Germany took over 2,700 since last April. That is not a huge number, but nevertheless, it's a part. it's an element to a broader solution. And in Germany, political, that it was after 2015 extremely important, and that is even part of the coalition agreement. This sentence, which was finalized in 2017, that the year 2015 should not be repeated, in the sense that not Germany should give a signal, whether intentionally or not, a signal to refugees and migrants that they are welcome in Germany. That because that led to an influx not only by Syrians but by other refugees and migrants, which on the political landscape in Germany should not be repeated. And that's why we said we will only act together with other European countries when it comes to showing signs of solidarity. And we have taken over about 70% with the 2,700 from Greece of all the European other countries pledging. So that is, on the one hand, the absolute numbers are limited. On the other hand, there is what I said, this migration fatigue, which we have in most of the EU member states. Maybe Germany, together with Portugal, Luxembourg, and Ireland, very much smaller than Germany, are the ones with the less intense effect, which we feel of the migration fatigue. On the other hand, what we are now faced with is secondary movement. We have in Germany about 1,200 people each month entering to Germany asking for asylum, who have been granted asylum already in Greece. That is a consequence of the speeding up of the asylum procedures in Greece and the huge increase of decisions in Greece. And we have lots of people from Syria and Afghanistan who come to Germany, which we only identified in the search in the Eurodac database or in the bilateral contact with the Greek authorities, that they have been already granted asylum in Greece. But they move on to Germany because they have family members here, because the living conditions for asylum for people who have been granted asylum in Greece are not the best ones, to speak to name it like this. And so that is really questioning 1,200 each month. That is really questioning the overall functioning of the system, which relies on the idea that when a member state has granted asylum, people have to stay for at least 5 years in this country, and they are issued by Greece refugee passports, and they are allowed to travel freely within the Schengen area, but only for a limited time, and then they ask for asylum. So that shows how the difficulty of the actual system, and that reduces as well from the German side the willingness to show further signals, humanitarian signals of solidarity, because frankly speaking, 2,700 are the ones we took over in a humanitarian gesture, and about 12,000 of the same group have made the way to Germany by their own. So that sheds a light on the discussion which you have on the political level. And as we are having elections in September this year, it's hard to predict, first of all, what the next month will bring on the migration issue, and even harder to predict what a new government, which position it will take.
We can only hope for the best, I guess. I would like, again, in view of the time, to hand over to Boštjan to give us his insights on the administrative court view, so the insights from the bench. Boštjan, thank you.
Thank you, Annette. And thank you also for extending an invitation to me to participate at this event. When we discuss issues of access in the field of asylum, we really need to distinguish between access to justice and access to asylum procedure, because the competent bodies for determining asylum claims are administrative authorities and not the courts. Courts around the world provide judicial control of first instance decisions, but courts in many parts of the world, for example, in the member states of the European Union, may also decide cases on merit and may grant international protection to asylum seekers. In addition, there is also the third issue mentioned by you, Annette, in your introductory address, and this is the issue of access to proper reception conditions, so that the right to human dignity of asylum seekers is protected during the procedure. So let me put access to justice in asylum cases in a broader perspective. At the beginning in Europe, the discussions and legal questions regarding effective access to justice for refugees were rather sophisticated. These considered questions on the appropriate and necessary scope and intensity of judicial control over administrative decisions on asylum. And since absolute human rights such as non-refoulement were at stake in those disputes, the European Court of Human Rights in Strasbourg introduced clear and detailed standards on strict judicial scrutiny already 30 years ago, starting with the Sering versus United Kingdom, Shehal and Weinbrenner cases. However, things started to be less sophisticated as regards access to asylum procedure and justice around the year 2012, well before COVID-19, when the first cases on the coordinated pushbacks at our borders and in the open sea came to the Strasbourg court. In this respect, I need to mention the Grand Chamber judgment of the Strasbourg court in the case of Hirsi-Yama and others versus Italy, where fundamental and extremely important standards on effective access to procedure and access to effective legal remedy, not just in extraterritorial context, were established for 47 European states. Therefore, these were not introduced by national legislators, but rather by an international court. I also need to stress that these standards on access to procedure and justice were introduced because there was a strategic litigation behind this specific case conducted by excellent lawyers and with the UNHCR office as an intervener in the procedure before the Strasbourg court. Soon after the Hirsi-Yama judgment, the rule of law in this field was further strengthened with the EU Procedures Directive, which in Article 46 imposed an obligation to the courts of the member states of the European Union to provide a full and ex nunc examination of facts and law in disputes against decisions of administrative authorities. The EU Procedures Directive also provided rules on free legal aid for asylum seekers in judicial proceedings. And thus here the EU legislator played a very important role. But it actually followed the standards of the Strasbourg Court on effectiveness of legal remedy concerning the protection of fundamental human rights. The Court of Justice of the European Union in Luxembourg followed the approach of the Strasbourg Court with references to the principle of autonomy of EU law. The Luxembourg Court made an important maneuver as regards the extraterritorial effect of EU law on access to asylum and protection of non-refoulement in the case of XX from 2017. In that case, there was an opportunity that the Court of Justice of the European Union would rule in favor of the protection of prohibition of inhuman treatment and would establish a legal access for genuine refugees who are threatened by inhuman treatment to come to the territory covered by the EU law in order to ask for asylum. Well, the Luxembourg Court did not take that interpretative opportunity, and so it left this issue to national laws of the member states. Thus, I come to the access to justice in the present situation of COVID-19. despite some 4 or 5 very important judgments on pushbacks that have been issued by the Strasbourg court after the Hirsi-Yama judgment going up until 2020, the so-called non-entrée policy at our borders, the policies of pushbacks and pullbacks remained in full operation when the COVID-19 crisis hit our societies. There have been some important judgments of the national courts against policies of pushbacks, starting with the Supreme Administrative Court of Poland in 2018, and the court in Rome, the French Conseil d'État, and the Administrative Court of the Republic of Slovenia, and also the Constitutional Court of Serbia in 2020, during the COVID-19 crisis. And this is also the case with access to justice in the field of refugee law. However, today there are still too many pending cases at the Strasbourg court against states because of their pushback policies at the borders that have been conducted prior to pandemic, including against Italy, Poland, Latvia, Greece, the Netherlands, Hungary, Spain, Croatia, North Macedonia. Panelists from yesterday's first session, Stephanie Boyce and Joanna Corner, pointed out that the rule of law crisis started prior to pandemic. And this is also relevant for the access to justice. Therefore, new restrictions to access to state territory starting in March 2020 due to national measures to prevent spread of the coronavirus have only added further obstacles to get to the asylum procedures and of course to get to the courts due to lockdowns, which in some states included courthouse closures. What I have missed as a lawyer in these early developments after March 2020 has been a professional debate about national rules on restrictions to access to territory and how they fit or conflict with the international obligations, including EU law on the common European asylum system. And secondly, as a judge in that first year of COVID-19 pandemic, I missed more forward-looking and strategic thinking about the consequences of this new format of executive rulemaking, which limit fundamental rights without at the same time having a standard form of judicial control. While some presidents of Supreme and Constitutional Courts and leading actors in judiciaries have reacted appropriately to these challenges with a strategic thinking and actions, some have not, or at least not yet. So what is ahead of us in the future as regards access to justice? Certainly, the dynamic struggle will continue between the concept of majoritarian democracy on one side and that of constitutional democracy on the other. The latter takes the fundamental rights of the least advantaged individuals much more seriously. I hope that the sociologist Niklas Luhmann was wrong when he said 50 years ago that in the future, the democratic state of law might only be remembered as an aberration in the evolution of mankind, and that only gained dominance for a short period of time. This was 25 years later, followed by the question raised by Jürgen Habermas as to whether democracy would survive globalization. For the time being, it seems that the future of access to justice in the field of refugee law will in many cases be dependent on the voluntarism and enthusiasm of lawyers and experts from NGOs on the ground. Even students of legal clinics and young refugee counselors who engage in strategic litigation in order to protect the rights of refugees before courts. Certainly, access to justice will depend on individual judges who are intimately convinced that their independence and professionalism are much more important than their promotion or other forms of recognition and reward, including their material well-being. It will depend on judges who actually exercise their intellectual courage and, of course, who possess some knowledge of international law. In this respect, I would like to highlight in particular the professional work of colleagues, for example, in Hungary, who by sending preliminary questions to the Court of Justice of the European Union on interpretation of EU law on asylum, provoked some seminal judgments of the Luxembourg Court on judicial independence and separation of powers and checks and balances in this field, like the Grand Chamber judgments in the case of Torubaro and FMS and others. Access to justice means nothing if it is not independent justice. In other words, I believe that judges are well aware that justice does not mean just us, especially under the given state of the rule of law in Central and Eastern Europe. Together with my colleagues, we try to cultivate the so-called ethos of service that Justice Robin Knowles mentioned yesterday. And we do these in discussions, particularly within judicial networks and judicial associations. In our association, the International Association of Refugee and Migration Judges, we have more than 500 members from all continents, while the European chapter of this global judicial association has more than 300 members, and these include Supreme Court judges. As long as we are here, and we are taken more than just seriously by other actors from private and public sector who are responsible for the rule of law too, I continue to have confidence in our joint success in the future. Madam Albright, former State Secretary of the United States, yesterday pointed out the importance of public-private partnership when we discuss strategies and programs to support the rule of law. Our association, the European chapter of the International Association of Refugee and Migration Judges, who is a private law, non-profit organization of individual judges, during the last 10 years established a unique partnership with the European Asylum Support Office. We even, in some sense, introduced soft changes in the organizational structure within the European Asylum Support Office, which is an EU agency governed by the representatives of the governments of the member states. Since this EU agency has got a mandate to develop and establish training for judges, my colleagues of the aforementioned association, we are drafting professional development series, judicial training guidance notes on all major aspects of EU refugee law, and we provide training based on these materials. So training materials and workshops are designed by judges, for judges, with full attention that everything we do in this partnership with the European Asylum Support Office is in line with the principle of judicial independence, despite the fact that EU hard law is silent on the aspect of judicial training and judicial independence. Namely, in the EASO regulation, judicial independence is taken as granted and mentioned only as a general principle, but judicial independence is not something that is granted. So we are acting and reacting each and every day with this having in mind in order to respond to every possible sign that might lead to jeopardize judicial independence. And that is why I still did not find sufficient time to tidy my office, as you probably can see. I thank you very much for your attention.
Thank you so very much. That was extremely impressive. And I do sincerely hope that democracy will survive globalization, and that we will reach our goals by a combination of what you and Ulrich have said. We'll have to convince heads of governments to come to terms on the politics level, but then we've got the grassroots movement of us lawyers and judges standing up for the rule of law and making sure that judicial independence and the access to justice in the broad sense, to the procedure, to not only the courts, but the asylum process is safeguarded. We're almost at the end of our panel. I would still like to give all the panelists the opportunity to ask any last questions if they want. Okay, so thank you all so much. Thanks to the fantastic panelists who gave us new insights and ideas for action to support the rule of law. It's up to all of us to make sure the rule of law is upheld. Thanks to all the participants out there for joining us on this panel. This unprecedented 24-hour webathon, lawyers across the globe and around the clock for the rule of law, does not yet stop here. At the top of the hour, we'll go live to Warsaw to join, and that's what you, Boštjan, just mentioned. Lawyers in all the different member states have their own challenges. To join the Warsaw Bar for a panel discussing the role of lawyers in protecting the judiciary, the Polish example. Thank you all so much for your participation. Thank you for listening in, and have a great rest of the day.
Many thanks to you, Annette. You did a perfect job. Tremendous.
Absolutely.
Thanks.
Totally agree. Thank you very much, everybody.
Thank you.